services, and I think early intervention is key and necessary to ensuring that we don't have some of the problems that we're seeing right now with our youth here in the county and especially here in the city. I look forward to answering any questions you may have, and thank you again for coming on.
Thank you, everybody. My name is Katie Kennedy McShane. I am a practicing criminal defense attorney here in Harrisburg. I have been a licensed attorney for 16 years, working in the litigation field for that entire time. I, like Latasha here, started my career as a prosecutor. For 3 years, I worked in the community as a prosecutor, working closely with law enforcement as well as crime victims, prosecuting misdemeanor and traffic cases. I left the district attorney's office and went into private criminal defense and have been doing that for the past 13 years. In my realm as a criminal defense attorney, I have worked with all types of cases, also working closely with law enforcement, with crime victims, with criminal defendants, from all cases ranging from theft all the way up to homicide cases. In addition to part of that work, I am in the courtroom here in the Dauphin County Courthouse as well as other courthouses around the state every single day. I have over 150 trials. That is. I've done countless other contested hearings in the courtroom. I have boatloads of courtroom experience. In addition to that experience, I've done as a chair on an arbitration panel. So I hear in the role of judge for small scale civil matters. I also work in guardianship for alleged incarcerated persons. So adults who are in handling their own finances who need a guardian. They also have rights that need to be protected. So I'm appointed to hearings. In addition to my court experience, I'm a mom. I have 3 children. I have a almost 17-year-old, a 7-year-old, and an almost 3-year-old. They are the most important people in my life, and that's my most important job. And I think that those 3 children have really given me a unique perspective on how to be a judge, because I can listen with compassion, fairness, and integrity when, dispute resolution, when you ultimately love dearly the people that you're listening to. I pledge to everyone who's listening here today to bring that kind of compassion when I've listened to arguments before me on the bench. Thank you.
Give me the high sign. Good evening. Thank you so much, Kia, Charla, very much for having this forum here at CATS, and I'm really pleased to be here. My name is Jim Zuye. I was born and raised here in Dauphin County, Middletown, Pennsylvania. Went to Middletown High School, and as I was telling, I believe, with Linda in the back there, that I remember pitching on some of these fields here at John Harris, as well as 7th and Radnor as a kid. After that, I went to Shippensburg University, where I graduated with a degree in economics and a bachelor's degree in government. And then I went to Widener University School of Law, where I was the first graduating class back in 1992. So if you do the quick math, I've been an attorney for 33 years. Right after law school, one of the best things about law school is, some of you may not know, I met my wife. She was a student who came in the second year. Her and I met. We were married in 1996. We've been married 28 years, been together for over 30. We have 2 wonderful children. Unfortunately, they are not as young as some of yours anymore. They're 25 and 23. They have now flown the coop in Washington, D.C. and New York City to embark on their own careers. And we were very fortunate as parents, because as good as parents as you can be, it takes a little luck sometimes. And out of law school, what did I do? Well, 11 years I went to the public defender's office. I represented individuals here in Dauphin County, the city, the Upper End, Londonderry Township, on a whole host of charges, hundreds, thousands of clients. From all the way from retail theft, and I've represented folks in death penalty homicide cases. For the last 21 years, I've been in private practice, both civil and criminal law. I think that's uniquely qualifies me to be a judge here in Dauphin County. Thank you so much.
point out for the record that Fran Charter was invited and he had a conflicting schedule situation, so he is not here, but still a candidate. I do want to read directly from Dauphin County's website about the role of the Court of Common Pleas and Judges for individuals that are watching online and both in the audience. The Court of Common Pleas is located in the Dauphin County Courthouse. The function of the Court of Common Pleas is the administration of the judicial system in Dauphin County, ensuring that the legal rights of all are protected and preserved. The Court of Common Pleas handles the full gamut of legal cases, including jury trials for criminal and civil matters, juvenile hearings, spousal and child support hearings, custody hearings, divorces, adoption hearings, estate matters, guardianship hearings, land use disputes, name changes, license suspension appeals, and emergency matters such as injunctions. So there's a lot that they cover. So we'll be talking about those different kind of aspects today. I just wanted to start out with a kind of grounding question. How do you plan to engage with the Harrisburg community to ensure that the court is responsive to the needs of all of its citizens? And we will start to.
How would we, I just want to make sure I heard correctly, engage with the residents to ensure that the court is responsive to their needs?
Yeah.
Okay. I have pretty much always been a hands-on individual, very accessible. Clients actually before we came in here, or they presented, the possibility. And so with the community, whether they were to see me out in public or at an event such as this, I would still avail myself and be very much present in the community to speak with young people, to speak with residents, to voice who want to voice their concerns. Now, as judges, of course, we have to be very mindful of any appearances of impropriety. So it would be inappropriate for me to speak about a pending case that person might have, or maybe their loved one. But I would welcome their issues that matter to them. I was just recently in a situation weekends ago, where there was a rapid succession of gunfire that went off at in Real, and I'm sorry, that would be Real, and somewhere in that area, not too far from where we sit right here today. And so that was a very deeply troubling situation. And I spoke with residents about that. I was out meeting with a friend and doing some canvassing that event occurred. So just always having an open ear to hear what concerns the residents, and then keeping that in mind when litigants come before the court and determining if we're talking a criminal matter, for instance, what would be appropriate in terms of community safety.
Can't be in charge of questions and clapping, so. Same question.
When it comes to making sure that the community feels heard, the most important aspect is listening. When we have litigants who come before you, whether it be a criminal matter, a civil matter, a custody matter, a land dispute, landlord tenant, whatever the case may be, for a litigant to feel engaged, they have to feel heard. And the role of the judge isn't to make new law from the bench, it's to apply the law as it is written. But in order to do that fairly, you have to listen. You have to actively listen to the people who are before you and make them feel like what they have to say matters. So it's not just about, sitting there while they talk. You sit, you listen, you give them their time of day in court, because that's what our justice system is about. We have a court system because people are not able to resolve disputes on their own. It is the role of the judiciary to provide a safe place for people to talk about how they feel, to share their side of the case, and to be given a fair and equal opportunity to present their case. In order for the community to feel engaged, they need to be given a fair opportunity to be heard. And as a judge, listening actively to everybody who appears before you gives them an opportunity to feel respected and heard in the courtroom. I also would welcome the opportunity as a judge to connect with children, probably high school age, community college, and help them understand what the role of the judiciary is in our community, so that when they come before the court, or to understand the role, so that they know how they can get involved and where they might be able to make a difference as they grow.
think one of the biggest things, we talk about experience, and we all have experience in our lives, and experience as an attorney. But the number one item that when you walk into a courtroom, I felt it as a litigant for my clients. When you walk into that courtroom, you must trust that individual in the black robe, that they will listen to what you have to say and decide there. That is the number one. I can tell you about my 33 years of experience. I can tell you, and you talked about all those things judges do. There's some things missing on there. I've done every one of those except an adoption in my practice as an attorney. There's actually, believe it or not, lottery cases that they do. I have not done a lottery case. Fortunately, they're about once every 15 years, and there might be some shenanigans at the PA lottery. But it's trust. And when you go into a courtroom, the worst thing you can hear from your attorney is, we pulled Judge so-and-so, because you know how Judge so-and-so acts. And I believe if you look at my record, look at who I am as an individual, talk about knowing the residents of Harrisburg, I want to say talking about knowing the residents of Harrisburg as well as Dauphin County. Lived here my entire life. I know what the community says. I've been a part of the community. I most recently been involved in an organization called Off the Streets. Off the Streets helps individuals. There's a lot of individuals out there who get help with money, but very few individuals get help with the security deposit to get themselves off the street, as well as furniture. And this organization gets furniture from individuals and helps folks move into homes. That's being part of the community. I also think, like I said, trust is number one. I've been trusted by the voters from this county several times. They trust me because I'm in charge of one of the most important things in their life, and that's their home, it's their food needs. I believe trust is number one. I believe thanks so much.
Moving on to restorative justice, what are your thoughts on restorative justice practices and how could you incorporate them into your judicial approach?
Thank you. I think justice is justice. And harking back to what I'm going to keep on harping about, trust. When you walk into that courtroom, you've got to feel, no matter who you are, whether or not what race you are, what sex you are, what sexual orientation you are, that you feel when you walk into that courtroom that you don't say, oh no, I drew such and such judge and I'm going to have this type of result. And I know that. I've been in those courtrooms. I know what that feels like, let alone the living it who's there. I've got to go up against that. And I've done that. And I think right now in Dauphin County, it has gotten better, but we're still not quite there. We want to keep continuing to get there. But when we talk about justice, justice is trust. Justice is knowing that the individual who's sitting up there in judgment of your case will follow the law and not look to your qualities that are immutable or some other quality and follow law, no matter if it's hard or not. And that's the most important part about justice that I've seen. I've represented thousands of clients here in Dauphin County. 11 years as a public defender, I want to harken back to that. That was not a brief stint in public defender's office where I moved on to the world. 11 years, rose to the second in command of the public defender's office. I had a chip on my shoulder because when I first started, one of my first jobs when I was in high school, I worked for the Borough of Middletown mowing grass. I was given a task to mow this set of grasses for the day. I did it. We knocked it out in one day. What I didn't know was that list was for the week. And I got it done in one day. That's not the way government should be. That's what I believe is important about government, doing the right thing, working hard for the citizens that you represent, and being trusted by them. Thank you.
Sentencing in a criminal justice system is unique to every case that comes before you, and there is no one size fits all. Not every case that is, XYZ crime should have the same penalty. As a judge, it's a difficult job to look at the facts for you to decide what the appropriate punishment is going to be. you look at the facts of the case, you look at the info of the victim that might be present, you look at the impact of the society, you look at the individual themselves, you look at the sentencing guidelines that exist in Pennsylvania, and you determine a sentence that is fair to everybody that's involved, that comports with the law in Pennsylvania. I agree with what Attorney Duguay has to say here, that you don't want to be the kind of judge that any litigant walks in there, whether they're the victim in a case, who's like, oh, this guy's gonna get nothing but a slap on the wrist. You also don't want to be the kind of judge where a defendant and their attorney is like, well, this is the worst spot. You're gonna go to state prison for 900 years. You want to be a judge who, you know, the defendant and the victim know that it will be fair, that they will look at the fact, that they will give a sentence that means something based on the facts of the case, based on the history of the defendant, based on the input of the victim, based on the sentencing guidelines, and on the law as it exists in the state of Pennsylvania. I likewise have represented thousands of clients and have been in front of many, many judges, some of whom I've been like, this is the worst. Some who've been, this is a great day, and some who I know, we're gonna go in here, and you're not gonna walk out of here scot-free, but it's gonna be fair. I was told by a very wise judge one time that there are people in the world that you are annoyed with, and there are people in the world that you are scared of. And the sentence for those people is different, and that applies when you're looking at sentencing guidelines and when you're forming a sentence.
When I think of balance and restorative justice, a lot of times I hear that term about the juvenile system, but I think that's something that can apply across the board when adults come before the court as well. And just piggybacking off of what some of my colleagues have said today, I think all of that is very important. And each of us has very different life experiences, and I think that that's very important when you are listening to the facts, because you will be listening to it with a certain context because of your own lived experiences. And so I would think on my lived experience, listen to the litigant and the facts as I find them, and then base my decision on that. If we're talking the world of criminal law, usually there's a victim. Sometimes society is a victim when we think of drug cases or sometimes gun cases. It's important to balance it out so that the offender is held accountable, but their life isn't thrown away for many, many years, I would say 900 years. That's very important because incarceration is unnatural. As human beings, we are not meant to be in prison, and I do believe that every human being has redeemable qualities. So I would have to balance that along with making sure that the community is safe. If we're talking in the world of civil litigation, making sure that the victim or plaintiff is made whole because they likely suffered a loss. Thank you.
I want to shift gears into mental health and substance abuse. What is your stance on the role of mental health and substance abuse treatment in the judicial process?
I think there's funding out there, city level, county level, and on the state level. I would demand of our elected officials to concentrate available funds on the area of mental health treatment as well as substance abuse treatment. Like I just said moments ago, incarceration, in my opinion, should be a last resort. Of course, if you have someone who engages in violent behavior, I don't think there are violent people. There are people who commit violent acts. If you have that, of course, you have to do what is best for victims and for society. But oftentimes there are underlying issues. There is underlying substance abuse. There's underlying sexual abuse and trauma that has not been addressed or treated. And I'm a firm believer that if we're able to address the underlying issue that causes the behaviors that we see in our criminal courts, That is the first step to ensuring that we don't have people engaging in recidivist behaviors, meaning committing crimes over and over again, because we are addressing the trauma that has triggered them to engage in criminal activity. I'm a firm supporter of funding to address mental health, substance abuse, as well as sexual abuse.
I think the mental health and substance abuse, mental health in particular, is the most underserved population of the community. Dauphin County Prison is our #1 mental health treatment provider in the community, and it really should not be that way. We send many people who have mental disorders who are incapable of taking care of themselves because they don't have family support, they don't have community support, and they find themselves sort of unwitting criminals who are unable to get themselves out of the system in prison, which is ill-equipped to manage the treatment needs of those who have mental health issues. Funding is a significant issue, but not necessarily the role of the judiciary. That is a commissioner's issue or the state legislature. But I do think that the judiciary can manage mental health differently by way of they do have a mental health. But it is poorly managed. But I do think that it's a program that could be incredibly successful that would keep people out of Dauphin County Prison, provide them with structure, resources, treatment, connect them with service providers, community resource providers, help them get off substance abuse and get them pointed in the right direction. Yes, funding is a big part of that I hope the commissioners would provide to us in the judiciary so that we can try to point these people in a better direction to get them the community support that they need.
When I became a public defender in 1992, each one of us as public defender, we do criminal cases. But one of the things we also do is we're assigned a kind of what we want to say an ancillary or secondary kind of expertise. I was appointed to do mental health. So back in 1992, I had you could call it this, but I learned quite a bit. I had the task of going and representing mental health patients all around the county. And I've done thousands of these cases. In fact, I was asked to do one last week, substitute for a person, for an attorney to represent individuals. So I was at Pennsylvania Psychiatric Institute as of last week. It is the #1 problem that we see here in the criminal justice system, mental health. And it's just not individuals who commit crimes, it's others individuals that find their way through court systems because they're unable to be cared for. Funding is a big deal, it is true, but we have to maybe rethink what we've done over the past how many years. One of those things is this. We closed the state hospital and they said, we need to put you folks in the community. That did not work. That did not work. There are individuals who need extensive support, and maybe that is long-term support. And then we just put them in a small little group home and are surrounding this because of the closure, because then in places that used to be open, like Edgewater, used to be a facility for mental health. I don't know if you remember some of those places. We now have very limited resources. We have Pennsylvania Psychiatric Institute, we have a little bit of Holy Spirit, and we have Katie said, we have Dauphin County Prison. We know that that latter one is not the right place. But as a judge, I can tell you that I believe mental health is something I'm keenly aware of and very important when it comes to litigants who become clients who become. Thank you.
What do you see as the most pressing issues facing family court today? and how would you address them?
Young lady came to me a couple months ago, said, Jim, I need help. She had a situation where she was being battered by her husband and she was trying to get away. She has a 9-year-old daughter. And that 9-year-old daughter was sexually abused by the father. That, she came to me because that individual, the father, came to her and immediately wanted to see her. Unfortunately, her staff there did not let that occur. He then went to her apartment and pounded on her door. We have evidence of that from her camera. And so we have a lot of conflict. We have a lot of abuse. And so I think that one of the biggest things that we have in that realm is conflict resolution, as well as a situation where it's time for responsibility. Responsibility, myself as a man, responsibility that when you are in the care of a child, you have a child you're caring for, it is just not a person. It's your child. And you need to accept that responsibility of that child and put the needs of the child above all else, including your own. That's what my wife and I did. There were times where we went without, we didn't do something. By no means did we do without much, but one of the things were that we said the children come first. And I think that's what needs to happen in relationships, whether or not you're married or not. You have children, that the child must come first. And once we start making that cool again, that the child comes first, then I think as a society we're going to do
I believe also, like what Attorney Zugay said, that managing custody in contentious divorce is probably the most challenging family issue that comes before the court. I have dealt with all manner of criminal cases, and nothing is more challenging than a contested divorce with children. Emotions are higher when there are children involved. People care more when there are children involved. People are meaner when children are involved. It is the job of the judge to make sure that you see beyond all of that, to look past all of the anger and all of the emotion to see the child. In every case, the child must come first. It is the job of the judge to look past what the parent is telling you and see what's actually going on in that household, to make sure that the child is in a place that is safe, where they're being nurtured, where they are being cared for, where their future is protected despite what the parents might want at the time. That is a hard decision to make when you're looking at a family that is being broken up and a child that is being torn apart. It's hard. I have never practiced divorce law, but I have a stepdaughter, and I have a good relationship with my husband's ex-wife. And despite all of that, sometimes the custody is hard. I live that every day, like who's gonna go where, who gets more time, and even though they have a good relationship, it is hard. And managing that for people who don't like each other and who have to get into the court, being a judge, you can see past that and say, you two sit down, we're looking at the child, and if that sometimes means taking a child away from those parents, that's what you have to do. And as difficult as that might be, the child absolutely has to come first. And that is without a doubt the most challenging thing that will come before the court in the family.
I would say, based on my observations and experiences, and so far as family court, and that's a really sort of broad category, but what kind of stands out to me are issues involving dependency. So you have juvenile dependency, you have juvenile delinquency. And dependency is where, for whatever reason, a child is not being properly cared for by their parent. And they are what we call a dependent on the system. And so the system, we the community, in a sense, care for that child. And I think it's important to do what we can as a court to help make the parent better so that there can be reunification of the parent and the child. From the juvenile delinquency perspective, there's a lot of that going on, and that's essentially where a child is accused of committing crime. You just don't call it crime. We have a whole different vernacular when we're speaking about children, but that's essentially what that is. And again, I say we need to focus on why is this child acting out? What is the trauma? What is going on in the household? What can we do to support and strengthen families and parents, the family unit, grandparents, aunts, whomever it is that is providing care and custody to that child, so that we don't see some of what we're seeing in our schools and in the communities, insofar as their behavior. So dependency and delinquency issues that stand out for me. Thank you.
Question from the audience: where do you stand with diversion when it comes to our youth? How will you connect with local organizations whom are working with our at-risk youth, knowing the climate we are experiencing with the youth today? Sorry.
Well, I think that there should be very serious vetting process of all diversion programs. There are, I think, some programs where the youth are involved in the people who may be running the program. We just want to make sure that they're the right fit for what is needed, because our kids are very impressionable. And we want to make sure that these are adults who are setting the best examples possible for our kids. I do think it's important that the people who are involved in the diversionary programs have certain lived experiences themselves, because that does give them credibility to the children. But we just want to make sure that, you know, they're on a straight and narrow moving forward. I do believe that diversion should always be key, unless, you know, we have a situation where a child needs to be temporarily removed from the community because of being a danger to himself or to someone else. But the goal should be diversion, because what happens is, you know, that 14, 15-year-old child is then a 26-year-old one day or 33-year-old one day. And they have these adjudications in their past. Adjudication is a fancy word for criminal conviction. And it catches up to them. And when you're a teenager, even though I extensively speak to my clients about the implications of admitting guilt to something or being found guilty, they don't have the life experience to truly understand what that means. And it does have long-lasting effects when they become adults. I'm all for diversion with the right adults.
The focus of juvenile court should always be rehabilitative in nature. That's the reason why juvenile court and adult court are not the same. Children are not fully formed in their brain capacity, and they do not think the same way that adults do. I agree with Natasha. You should have, you know, good diversionary programs, not just send someone out into the community like, hey, go get rehabilitated. But the focus of juvenile court should always be rehabilitative in nature. I also really strongly believe in community outreach with the youth, especially our at-risk youth, before they become a participant in the system. I work with Cameron Street and Unite Central PA Boxing. I got involved with that program with my husband. They're over on Cameron Street. They just moved down to the other side, but they do great work with the youth in our community. They get them off the streets. They say guns down, gloves up. It is an amazing program that they do with our kids, young men and women in that program. They get them in the boxing ring. It is a pro-social unity community group that really helps these kids get off the street in a community where they feel supported and motivated to move forward in their life in a way that keeps them out of the criminal justice system. And I think those types of programs, supporting those in our community, yeah, diversion programs in the court are great, but keeping kids out of the justice system to begin with are better.
Can you repeat that question again?
Yeah.
Oh, you're on to the
No, it's okay. I'm ready. I'm here. Where do you stand with diversion when it comes to our youth, and how will you connect with local organizations whom are working with our at-risk youth, knowing the climate we are experiencing with the youth today?
I think that the colleagues have said here this evening, I think that we are in a situation where most judges, if they're in the juvenile system, that it is a diversion program. In other words, they don't get a criminal conviction. But as Tasha said, the adjudication of a juvenile is truly a criminal conviction and can come back to bite them. Your sentencing guidelines if it is serious. And so we have to be very careful, as you said, that we need to prevent them getting into the system. One of the things as a judge, unfortunately, I don't think we can be so proactively involved as a judge doing those things. But we have to vet these programs because every time you turn around, there's a new program. You have to make sure as a judge before you would say, hey, let's go to this program, that you don't send a young 12-year-old to a program and they could be abused there. That's what you need to do as a judge, is to make sure the programs that you sentence someone to or send to or say, please go to this program and we can then absolve you of the offense. We have to make sure that those are held to account. In fact, I think one of the important parts about doing when I've done juvenile law is to actually bring that stakeholder to the table. And I don't mean to the table in just sending them there. I think they, as a judge, what I would do as a judge is have that individual group, whoever they may be, in the courtroom so that I make it clear to that basically community outreach group that I am putting this individual in your care. And if you do not do what you're supposed to do, I'm not going to hold that child accountable for that issue. I'm going to hold you accountable.
What are your views on access to justice for low-income individuals, and what initiatives would you support to improve it?
I don't think I've ever done that, where I've assisted low-income individuals for 11 years as a public defender. What do I do? As a judge, there's what we need to do, gets back to that trust factor, is that we need everybody to be heard. That's number one. But we have to make sure as a judge, when you sit there and you see there's a situation where maybe, let's just say the public defender's office. I know when I was in the public defender's office, there was a lot more district attorneys than there were public defenders. And I think we worked with the commissioners to make sure that that balance occurred. And we not only pointed it out on the fairness aspect, because you have those people that obviously want to be fair, and they want to make sure, because the best trial, best court or access to justice is when you have a very good prosecutor, and you have a very good defense counsel, and you have a fair judge. Then the jury makes that decision as to what should happen. That is the basic, what I call a four corners square: judge, jury, prosecutor, as well as defense attorney. We're talking about the criminal aspect. That must be all supported by the county. And if there's a situation where I feel that that's not being supported, we, some of you folks don't know, but the judges in Dauphin County, they get together once a month, usually the first Thursday of every month, and they get together for a dinner. And at that dinner, they talk about things. And I've never been there, so I don't know if I want to be. But it rotates, so they keep it going, right? And at that meeting is where I would, if there was a situation where I didn't feel access to justice was happening for an individual group, or attorneys were not doing their job, I would voice that to make sure whoever's representing the individual, it doesn't have to be criminal law. It could be dependency, it could be custody, it could be conciliators. If they're not doing their job, I want to raise that concern.
there's a bit of a misconception sometimes in the public that public defenders are not very good at their jobs. And I have worked as a prosecutor and a private defense attorney for many years, and some of the best defense attorneys I know are public defenders. I never practiced as a public defender myself. My husband was a public defender for many years, and I know many public defenders, especially here in Dauphin County, who are very good attorneys. They have lots of trial experience. And I think sort of trying to waylay that misconception among the public would make people more comfortable and confident in their counsel. The number one complaint that I hear from clients who have public defenders who call me seeking additional representation is that they don't have enough time to talk to their attorney. And the way to solve that is more public defenders. And that's a hard question to solve because, again, it comes down to funding availability. Even finding more attorneys to work in our private law firm can be a challenge sometimes. And I think assessing budget, when you look at, like they say in these judges meetings, when you look at the budget for the county and what kind of resources we need, more public defenders who are available in the criminal justice system so that these good attorneys can actually give the attention that their clients deserve and have access to their community so that the clients feel represented. Though they have a good attorney, they just need to be able to communicate with them. I think one of the other issues that people have trouble with sometimes in court, the way that they do court in Dauphin County, everyone shows up at the same time. Private counsel always goes first. And so people who end up with public defenders often sit around for a long time waiting, and it's a whole day. I think that there may be ways that you can manage scheduling that would save time for people who are represented by the public defender, so they don't have to spend the entire day sitting around in court, so you can recognize from the court system that their time also matters. And I think that that applies to all realms of court. We're talking about criminal here because I think when it comes to access to justice for low income, that's where the number one concern comes in. And I think that there are many ways that we can navigate this system to allow people to understand that access is out there and just helping the community connect with the resources that are available, which change a lot of things for people.
Yes. So there are not many areas in the law where a person who has low income is actually entitled to an attorney. So I think that's a big part of the problem. We're just talking about criminal defense for adults or juvenile law for children, dependency, I talked about earlier. Sometimes when there's an incapacitated person, but that's really about it. I think it does boil down to funding. So I would advocate for more funds. Pennsylvania is, I think, the only state or one of the very few states where the funding comes from the county for public defenders and not from the state. And so I would advocate for, and not necessarily in my capacity as a judge, it's very important that we keep the three branches of government separately, but I am still a taxpayer, I am still a citizen, I'm still a voter. So I can, in my own way, still advocate for the necessary funding so that everything that Attorney McShane says is very true. There's long lines to wait. There's not enough attorneys, but that's because there's not enough funding going towards public defense. Reaching out to the law schools in the area, we do have two Widener University Law Schools, which is my alma mater, as well as the Dickinson School of Law. Sometimes the students graduate and then they leave the area or they go into private practice. So working with the schools to sort of encourage them to remain in the area and to devote maybe the first couple of years post-graduation or post-bar licensure to public defense, because if we do have more attorneys, I think that will help in terms of getting access to more people.
The next question is about sentencing practices. How do you approach sentencing, particularly in non-violent offenses? And what factors do you consider most important?
Every case is very individual. There is not a clear recipe, in my opinion. I think the Attorney McShane would mention sentencing guidelines before. And guidelines are just that, in my opinion, they are guidelines. And there are going to be times when a person should be sentenced below the guidelines. And there can be times when a person should be sentenced above the guidelines. And when that happens, the judge has to give reasons on the record as to why the sentence is above the standard range of punishment. If not, that sentence can be reversed on appeal in the Superior Court. So for me, I will vary, and again, it's very fact specific. It's just not a cookie cutter situation, and what litigants would know coming before me is that I would be fair and I'm going to be consistent. So on Monday, if there's a sentencing of a person who has a prior record score, which is basically a calculation of all the bad that they've done in their past, prior convictions of 5 for carrying a firearm unlawfully, they're going to get the same sentence as the person who comes in Tuesday with the exact same factual circumstances. Now, there are times when the government comes into an agreement with a defendant and they negotiate an agreement. I would probably, for the most part, respect the agreement, but I would not be afraid to reject that agreement if I felt that it was too lenient or if I felt that it was too harsh. And in that case, the person would then have to go to trial.
I did speak a little bit about sentencing before when we were talking about restorative justice, and all sentencing in Pennsylvania really does have to start with the sentencing guidelines. It's the law, and it is not the judge of the law. It is not the role of the judge to sort of do whatever they want. It's the role of the judge to follow the law. You start with sentencing guidelines, which are based on the offense gravity score. So how serious is the crime compared with the offender's prior record score, which was how many offenses they've had in their past. And it will give you a range of months based on their offense gravity score and their prior record score, and then it will give you a mitigated range and an aggravated range. It is the job of the litigants to present to you as the judge the facts which are either aggravating on behalf of the Commonwealth or mitigating on behalf of the defense, and for you as the as the judge to sit and listen fairly and equitably to those factors and make a determination on a case-by-case basis how those facts fit the sentencing guidelines. Like the top said, in order to go above the standard range, you have to put the reasons why on the record. And sometimes there are going to be reasons why someone deserves an aggravated range sentence. Probably not very often in a non-violent offense. There are going to be reasons why someone deserves a mitigated range sentence. If an offender comes before you and they've taken lots of steps to address the underlying issue, say they have an alcohol problem, which resulted in the offense, they got them before court, they've taken steps to maintain sobriety, they've got treatment, they have their 90-day AA chip, they're doing all of the right things, those things are going to play a role in sentencing as well. And I think that it's difficult to say, like, I'm going to do this type of sentence on this type of crime every single time. It is looking at all of the factors, applying the law, because it really is, the sentencing guidelines are part of the law in the state of Pennsylvania. Applying that appropriately to the facts, I think.
The hardest thing to do is to judge someone as to whether or not they're a good person who did a bad thing, or they are a bad person who did a bad thing. That's one time, I believe, Judge Morrison, who is the president judge of our court, it told me and said that is the most difficult part. He also said I put hands with the devil's workshop too. So two things I believe said as president judge. To do that as the judge, we think about but as the judge, you have, and we talked about nonviolent offenses. Nonviolent offenses, most likely there is not going to be a jail sentence.
an offense against many different individuals. I think there could be a possibility with, say, we look at that individually and there were multiple victims. That's where I think consecutive sentences might be applied. But again, for us to kind of say, hey, we would give consecutive sentences here or give consecutive sentences there, I think it's a rare occurrence, at least in what I'm seeing today, because I think folks have realized mass incarceration is not necessarily the answer.
I certainly think that there are circumstances and cases where a consecutive sentence would conceivably be appropriate. There are also cases where a long term of probation without incarceration would likewise be appropriate. Probationary sentences are useful when you want to be able to keep tabs on a person who you don't think necessarily deserves to be incarcerated. They've shown some steps that they are trying to work on themselves, or that maybe they're kind of a borderline and you don't think they deserve to go to jail, but they need some consequences. Because obviously when you commit a crime in the state of Pennsylvania, consequences are part of that. They're part of you play that game, you win that prize. It's part of what happens in the community. Probationary sentences can be a good compromise from straight incarceration. They give a person opportunity to be on the street, to continue to care for their family, the opportunity to continue to work. And sometimes long probationary sentences are important. They matter if you have someone who you think needs that kind of supervision. Not every case is going to need that. Not every client is going to need a long consecutive term of probation. But again, these kinds of questions really, a criminal case, I've done thousands of them and no two are alike. I do a lot of DUI casework, and a lot of people might think all DUI cases are the same. They're not. No DUI case is the same set of facts. It's not the same person. It's not the same prior record. It's not the same circumstance. And so the sentences are never the same. And every criminal case, you have to look at the facts. You have to look at the person. You have to look at the circumstance and factor in a sentence. It's going to be appropriate based on all of those things.
Yes, I echo those sentiments. Again, there's no cookie cutter justice when it comes to sentencing. As Attorney Zugay said, that first scenario, that would be an illegal situation that hopefully someone would catch, either the prosecutor, the defense attorney, or the judge would catch it and correct it in an appropriate time frame, which doesn't always happen. But there are times when consecutive sentences are appropriate. And again, it just really depends on that specific situation, the impact on the victim, provided that there was a victim. But I think this piece is not something that we see often, because, and I don't have data in front of me, but a good portion of the time, sentencing is negotiated between the parties, between the prosecutor and between the defense attorney. And so unless a person pleads open, which means there is no negotiated agreement, the judge is setting the sentence, or sometimes it's sort of partial, where there's an agreement as to what the maximum will be, or there's an agreement to a certain condition of the sentence, and then the judge sets the other part of the sentence. So I don't know that this is something that comes up frequently, perhaps in the context of probation violations, how to handle that when a person's been on probation or county parole, and then they are found to be in violation of the conditions of that probation and parole, and then the judge imposes a new sentence. But just generally speaking, that initial offense, I don't think that it comes up that frequently, because most sentencing is negotiated. But if it does, I would judge that on a case-by-case basis when a consecutive sentence would be necessary, such as when there are multiple victims, like Attorney Zugay mentioned. Thank you.
Another question. Considering the aging population in Harrisburg, how would you address issues related to elder law and the protection of vulnerable seniors?
Again, I think that comes down to funding. as well. Everything is always about money. It comes down to funding and what can we do just as a society to ensure that our seniors are cared for, that they are supported either by sometimes younger family members. There are situations where our older community members are deemed to be incapacitated. And so the court appoints people to ensure that they are cared for, to ensure that their finances are being handled appropriately. And so again, funding to make sure that from the court perspective, that there are enough attorneys and people available to ensure that they are not being mistreated, either physically or financially, and ensuring that tough penalties are meted out when cases of elder abuse that are criminal in nature do come before the court. Because our senior citizens and our children are one of the most defenseless populations in our society, and it's important that we do protect them. Thank you.
Concerning the aging population of all communities in Harrisburg, I think that that role comes into play in all aspects of the court, from criminal, family law. I represent or act as a guardian in court-appointed guardianship cases. I work with, adults who are younger, who have mental disabilities, but also aging adults who can't care for their own finances. And I think one of the things that is the most important is making sure you have education for community members about how to be a guardian, the resources to become a guardian for those aging populations, how to appropriately care for those adults and their finances, how to seek assistance for managing their financial and their estates, and how to make sure that those adults and their seniors are not taken advantage of. As a criminal defense attorney, the number one thing I see is that people who are hired to take care of senior citizens take advantage of them in so many ways. They steal from them. They do not provide adequate care. They are, left alone. They're not given food. They don't get transported to their doctor's appointments. Their medications are stolen. And providing resources to our senior citizens so that they get the care that they need, that they are safe, that they are protected, that they need all of the things that our children need. They need to feel loved, comfortable, fed, warm, safe, that they feel safe and cared for in their own home. And so providing training for guardians, better resources for companies like Home Instead, who provide in-home care for senior citizens. Well, they're a great program. They helped take care of my mother-in-law when she fell and broke her elbow. And providing more sort of resources for that. As a judicial candidate, there's not a whole lot really that we can do to get involved in that part. But for, I think, recognizing when we're appointing guardians and participating in that sort of guardianship role, and as a criminal judge, when people are taking advantage of that, making sure that we recognize that those types of crimes are just as serious, maybe more so because of the vulnerability of that population.
I sort of have an affinity for older folks, seniors. My dad had me when I was 54 years of age, and my mom was 44. You could say I was a mistake. And I'm glad I'm here, one way or the other. So by the time I knew what end was up, my father was darn near 60 years old, and my mom was 50 years old. So I grew up in a household with elderly folks. One of the things when I first started practicing, Judge Hoover, when he was president judge of Dauphin County and who has subsequently passed away, he created a program called the Guardian Monitor Program. And prior to the Guardian Monitor Program, folks do a lot of estate work, guardianship proceedings, and folks were being appointed a guardian, and no one was watching over them to see whether or not they were doing the appropriate things. And they were not. Now, 95 probably out of 100 times, folks were, if they did something inappropriately, it was because of they didn't understand something. They weren't doing something nefarious or bad. But 5 out of 100 are too many. And so what Judge Hoover did is he asked the attorneys in this area, and I was one of the original members, to be appointed where I meet twice a year with guardians who are appointed by the court. I sit down with them. I make sure that, and I visit with them. I visit with the person they care for is called a ward, W-A-R-D. And I sit down with them and make sure they have a good interaction. I check into the finances, making sure that money is getting spent. So I actually go on site to see these folks. That was a quick minute and a half. My goodness, I got a lot to say here. So I think, and I volunteered for that program. I have been able to help so many folks in that program, and I think that program needs continued. I think that is a great way for members of the bar to give back, and I'm pleased to do that. So thanks for the question.
We recognize in today's society that the laws are working to become both liberating and seemingly oppressive to certain marginalized groups. I'm interested in getting your thoughts and feelings around the current climate of how judicial systems are working when it comes to civil liberties and social justice.
Well, I think we can, boy, that's a long question. That's
Maybe a 3, yeah,
Maybe 3.
3 minutes,
A
maybe.
little bit of sauce. Yeah. a little bit of sauce.
I'll make it 2. I think I can, if I wanted to be a legislator, I think that would be a terrific question for me. But you're asking me to be a judge. And so one of the things I have to do is I don't legislate. I won't legislate from the bench. I'll follow the law. But obviously I can recognize if there are inequities and bring them to folks' attention. So that's what I plan to do. Let's harken back to a part where we talked about that I went into courtrooms and you knew what the result was going to be. Or you walked in there and knew your goose was cooked because the person may have been a prosecuting type judge and they favor that group. What we need to do, us 3 as individuals, is promise, and you have to look at our records and what we've done in the past, to be a judge who is fair and make sure all sides are heard. We talked about that. Number 1, I was involved in a case, and I keep bringing up these examples because in real life, there was an example in a guardianship procedure. I might need that extra minute, doctor. In a guardianship procedure, I was attempting to help my client get her mother appointed a guardian because she was not of sound mind, but it was close and it was not, we weren't sure. And she would not sign a power of attorney, but she was not able to care for herself and no one was paying for it. So we had to go to court and it was a long proceeding, and the judge, there were other family members involved who were not kind of on the side of my client, but they were not parties to the litigation. So in other words, it's myself, my client, the judge, the mother, and the appointed counsel for the mother. Now, let the family talk because one of the family members raised their hand during the hearing. Now, is that necessarily appropriate? And when that individual raised their hand and got 10 minutes to speak and was not disrespectful but had legitimate questions and concerns, when the judge allowed that to happen, that individual sat down and felt like they were heard. And that made the situation diffused, a more volatile situation. They felt they got something off their chest. Were they a litigant? No. Could I have objected? Yes, I could have, but I didn't because of that situation. That was a good judge that did that.
I agree with Attorney Zugay, and the basis of that question is a great question for the legislators here because they're the ones who make the law. They're the ones who decide the law. We here as judges, we rule on the law, we enforce the law, and the only thing we can do is enforce the law as it's written. But it's important that we enforce the law as it's written equally to every person who comes before us, regardless of race, gender, age, political affiliation, religion, size, shape, color, it doesn't matter. Every person gets the same opportunity to speak. Every person gets the same opportunity to be heard. Everyone will get from me the same active and engaged listening regardless of who they are, regardless of what they have to say. I will be there to listen to them because that's my job as a judge. I think the best way that we fight back against that marginalization is to enforce the law equally against everybody. You don't pick and choose who gets a sentence. You don't get a better sentence because you have a more expensive lawyer. You don't get a harsher sentence because you showed up without counsel. You don't get a better sentence. You don't get more custody rights because you're a mom. You don't get less rights because you're a dad. You get what is fair to you based on the circumstances of your case. And the way that we fight back against that marginalization is to close your eyes to what appears before you, listen to the facts, and apply that equally, and to follow the rule of law. I believe firmly in the rule of law. I believe in the Constitution. I believe in equal rights for every person. Every person who appears before me will get the opportunity to be heard, and they will be heard by me.
There's a saying that justice is blind, but for me, I actually have to open my eyes and not close them and look and see who is standing in front of me. Because as a Black woman, as a Black attorney, I can sit here and say that it's not a fair system for people of color. Even as an attorney, there have been assumptions made when I walk into a courtroom that I'm the stenographer or a defendant. No shade to stenographers, but that's the assumption that is made. And so I have a case right now where, well, it's over, but the client is Black, and he was going to trial, a jury trial. And at the break for the day, the client went and made a Facebook video, and he posted that he was in a particular county on trial for something that he did not do, and that the county was racist, that everyone was racist, that the judges were racist, his defense lawyer was racist, the prosecutor, everyone was racist. And to make a long story short, the government, who did not appreciate this Facebook post, they found out about the video in the course of trial. The trial was terminated. He was thrown in jail with his bail revoked, and he was charged with jury tampering. It was the craziest thing I'd ever heard, all because he spoke his truth. I eventually got on the case and filed necessary motions, and the judge did dismiss the case. But that only happened because I stood up and advocated for him as his defense attorney. As a judge, there will be times where I won't know everything that's happening behind closed doors because the government knows what they know, defense counsel knows what they know. But if, based on my life experience, if I smell something that does not smell right, I'm going to step in, likely encourage the parties to talk about what's going on because I know what I know. And I'll just leave it at that. Thank you.
When determining bail and sentencing, how would you consider a defendant's financial situation given our county's economic disparity?
You're thinking me.
Yes.
Okay. So because that question kind of looks at the beginning of the process and the end of the process. So I guess I'll touch on the bail piece first. The financial situation is important, but there is criteria that has to be considered when looking at bail. And I would consider all of it. So you're looking at really the person's propensity for not showing up at a trial. Is this someone who has ties to the community? Is it more likely that they're going to take flight and not appear at their next court date? Are they a danger to the community? These are just some of the factors that are looked at with regard to bail. And so again, on a case-by-case basis, I would look at that. And if something needs to be modified, because bail is 9 times out of 10 initially set by the magisterial district justice. So if something needed to be modified and that were brought before me, then I would take the necessary action. And it gets really tricky because if you have a really crappy attorney and a lot of people do. You know, a judge cannot sua sponte, or Latin for sort of just on their own, take certain actions. It has to be brought before them by that person's counsel. And there are a lot of attorneys who are terrible. They don't care. They don't care about defendants. They are incompetent. They don't know the law. And so as a judge, I have to be mindful of what is brought before me. But if I blatantly see something that is unjust, I would not be afraid to correct it, you know, within the boundaries of the law and my role. Because while I'm not an advocate for the government or an advocate for the defendant, I'm still an advocate for justice. And that's what's going to prevail in my books. Thank you.
Again, like Latasha said, bail is most of the time set by a magistrate judge. Bail modification, the most oftentimes that we would see in the Court of Common Pleas would be a bail modification request. I would say 100% of the time, in less than sort of extreme circumstances, a magistrate judge is setting initial bail in a criminal case. And there are very specific factors that have to be considered when you are looking at bail. You look at a defendant's ties to the community. You look at their prior criminal history, and you look at the seriousness of the crime. The purposes of bail really are twofold. Is the defendant likely to fail to appear for court if they are let go from prison? And is the defendant going to be a risk to the community? So bail is ensuring someone's appearance in court and is ensuring community protection. When you're looking at when you're looking at bail factors, really a client's ability to pay is not something that is one of the listed factors in bail. If that's something that should be considered, maybe we need to reach out to legislators about that. As a judge, it's not my job to change the law, but it is my job to look at those factors. And it is something that I would consider. What are their ties to the community? What is their prior record? What is their likelihood to flee if released from prison? Am I going to ensure their appearance in court? And am I going to ensure that the community is protected? And those are the factors that I would always consider when setting bail, because that is what is required by me, by the law.
Bail is not punitive and should not be. I don't know where that has kind of come circle in my years, but it seems like you hear more and more times where a judge sets bail because they're angry at a certain matter. And I don't know where that went awry. It should never be punitive. As both counsels have said, it's to guarantee your ability to come to the next hearing. And as Katie said, also a factor is, are they a danger to the community? Now, that is very, very minimal amount of times that's in the scheme of things of all the cases. But at no point should a judge use emotion and get angry at a particular defendant or say, well, you've got a lot of money, or you've got this amount of money, or you've got this. You should set bail to make sure that they appear in court. And that really is what bail should be about. It should not be punitive or emotional, because that's what I've started to see during the latter part of the career. There have been particular, as they indicated, magisterial district justices who for a particular crime, you saw the same amount of bail, high bail, like $100,000. And that's not right. And never should be right, because again, every case is different. So when you walk into my courtroom, you will not have a judge who believes bail is punitive, or we should be setting high bail in every particular case, because every case is different. So, thank you.
Questions from the audience? I reworded it for conciseness. Can you give a statistical snapshot of your rulings throughout your career, and what do you think that says about you as a judge?
Well, I've never given a ruling because I'm not a judge yet. But actually, I understand. But actually, this must be a setup. Somebody was good and they wanted to bring out a point. As many of you know, I'm the recorder of deeds for Dauphin County, have been for 21 years. And one of the things that I have been asked to do many times is I've been appointed by Dauphin County courts to decide what they call partition actions. What in goodness gracious is a partition action? Well, a lot of times, folks aren't getting married as much anymore, but they are buying a home together. And so when you are not married and you have the split and you're on the deed together, you don't go to divorce court. You don't go to family court. You go to partition court, all right? And a lot of judges don't do this. This is very kind of a unique thing, but it is happening more and more. I've been appointed by the courts to serve as a master in that role, where I actually stood in the place of a judge as a master and listened to both sides to decide that. I think that was it was an honor to me, and this was all free of charge. This is because I believe that's what we should be doing as much as we can of, is volunteering our time and doing those types of things. But I've also been appointed as a master in those mental health cases that we talked about. In a mental health case, as some of you are familiar with these numbers, 302, 303, 304, 305. It's under the Mental Health Procedures Act. Did I do something wrong there? Okay. Under the Mental Health Procedures Act, those are statutes. And when an individual is placed into a mental health facility against their will, they have to have a hearing under that section. And there are masters who decide those things. And I have been appointed to fill in and do that when the regular master is not available. And I've done that. So that is my role as been a judge, and I think I've done it fairly. And obviously, I think the courts are pleased because they keep appointing me to do it.
I, like Attorney Duguay here, have no judicial rulings to speak of. I've not yet been elected as a judge, so I hope to have many in my future. I have served as a chair of an arbitration panel, which acts as a role of judge in sort of small scale civil actions. And I suppose as a statistical snapshot in those rulings, I think we probably have gone equally 50-50, as best I can guess, in favor of plaintiffs and defendants. And the types of cases you hear in arbitration are like small claims, personal injury and car accidents, creditor disputes when it comes to a credit card debt, things like that. And they're unique and interesting cases, and it really is like a small scale snapshot of what a court of common pleas case would hear. The primary difference is that you're sitting with a panel of judges, so there are three of us who sit and decide. But you listen to both sides of the facts, you decide together. In some of the cases we found in favor of the plaintiff, and some we found in favor of the defendant. Not all cases are cut and dry. There were some cases where the plaintiff was asking for, a certain amount of dollars. We didn't award them as much as they were asking for, but we did think an award was, appropriate in some amount. But again, I don't have a lot of judicial experience because in order to become a judge, you first have to go through this process and be elected. So that's why we are all here tonight. And I hope that someday in the future, someone can ask me that question and I will have an answer for all of you.
And similarly, I have not yet been elected as a judge, but I have served on arbitration panels in the past. And again, that's wherein you have a dispute, you have a plaintiff, you have a defendant, someone was harmed in some sort of way. A lot of times it's financial. And I sit on a panel with two other attorneys. We listen to the facts, the witnesses take the stand. And then once the evidence is put on, we make a decision. And so just depending on the evidence in those cases is how, the ruling has come down. But outside of that, that would be my only sort of judicial experience in that regard.
Last question. How would you ensure that you uphold the highest ethical standard as a judge? Okay. We've been doing this all night.
I was just checking. Ethics is very important. I think that, I have to lead by example. First and foremost, recognizing that I am not above the law. And so I have to hold myself accountable in every way. That's really like a loaded question because Wow. Yeah. Not above the law, and no one else is above the law. So if someone were to appear before me, and this is in any context, criminal law, family law, civil division of court, no matter who they are, where they come from, they are going to be treated fairly, but they're going to be treated the same as the next person. To me, that's integrity, that's ethics, and but it has to start with me. Of course, none of us are perfect, but I have to lead by example. I have to walk the walk that I talk. And just accountability is key, again, starting with myself. Thank you.
I would say to myself the same thing that I say to my children. You must always do the right thing, even when it's hard. As a judge, we are going to be faced with sometimes impossibly hard decisions, but you always have to do the right thing. It is our job as judges not to be above the law, not to be beside the law or to make the law or change the law or suit the law to fit what we feel like that day, but to enforce the law as it's written, even when it's hard. I believe in the law. Like I said before, I've said that many times. I believe in the law. I believe in enforcing the law, even when it's hard. And there are going to be times when you want to take a shortcut and maybe you don't want to do that trial because you have somewhere else you'd rather be. But that is not fair to your litigants. It is not fair to the clients. It's not fair to the victims. It's not fair to any other person in the court system. And as a judge, while you're sitting up in the high chair, really you're the least important person in the room. Every other person in that courtroom is more important than me on the bench. I make the decision at the end of the day, but I don't matter as much as anybody else who's sitting in there. And I will remind myself of that every day. Every other person in there is more important than me. I am here to serve them. I am here to serve you. I am here as a judge to serve the needs of the people of Dauphin County, to provide services to them, to help them solve the problems that they cannot solve. So I will always do the right thing, even when it's hard.
Can you repeat it again?
Yes, I can.
I'm trying to get extra time from the doctor. Not happening.
How do you ensure that you uphold the highest ethical standards as a judge?
I think number one, you have to look at someone's past as a judge. In other words, our experiences, and look to see if we've been trustworthy in the past, if you can trust us. And that's the first step in getting us there. The second step is real easy for me. My mom and dad, obviously, my dad was 54 when he had me. He was born in 1913. He's no longer here. My mother, born in 23, she's no longer here. But there are three ladies who make sure that I do what I need to do. And that is my wife of 28 years, who makes sure I will be ethical and doing the right thing, because she reminds me every day of doing those things. And when I don't put something away or do something incorrect, she's right there to correct me. And the two daughters that are 25 and 23, they make sure that Dad, because we taught them. It's so funny, now that they're older, a little bit older, they are, it's so nice because once in a while I may say a bad word and it might be in front of them. And you better not be recording this, all right? And I say a bad word. And you know who corrects me? My daughters. And you know what? And it's a great reminder, because I feel good because their mother and I kind of planted that seed, and it reminds me that I don't need to be saying that. And so I think it comes down to your own personal self, your God, and your family. And there's nothing worse than, to me, is embarrassing, not to me, but it's to my family, that I would come home and do something I shouldn't have done.
All right, let's give them a round of applause. Thank you. I will say that there were some outstanding questions that I do feel were answered by some of their answers, but I invite you guys to take these last couple of minutes, if you feel like you did not get your question answered, to have a conversation.
Please do. I'll stick around.
Yeah,
I'm happy to answer whatever questions you guys got.
Me too.
What?
Are you saying have a conversation now or afterwards?
Okay, give me 1 second to wrap it up. So I do just want to thank everybody for coming. Thank you to NCBW and thank you to Ted for everything you guys have done. This is the last forum, so thank you guys for sticking with it.
And thank you, Anna, very
Thank you very
much.
much. Thank you for having us tonight.
Before we go,
Oh,
I'd like to first thank Mr. Tariq Castillo. This is his building.
Thank you.
Those of you who don't know him, he built this.
oh, wow.
It's a beautiful building.
This, the vet center, and the 50 minutes out on the street. And on behalf of NCBW and we would be remiss if we didn't give you just some flowers. I hear yours in the snow. I know we're talking about appreciation.
Very nice.
I didn't get a good picture all this entire time. Can someone right now?
Yay! Okay, can we have a birthday on the panel?
I do.
It's her birthday.
Thank you very much. Thank you.
Well, I know we'll stick around. You'll probably, everybody here will stick around. Feel free to ask us any questions.
Thank you guys.
Thanks so much.
Thank you, Anna.